Did you understand what I just said?
Can we agree to disagree on a legalese?
We are not going to agree to anything. This is not your game to play here.
So you're saying that I have to say the words, I understand?
Sir, I'm not saying that you have to say anything. You can play games with me all day. I got all day. I got all day. Have a seat. Do not interrupt me.
I can object to
Do
that.
not interrupt. Do not. One more time. You're going.
I expressly do not consent to this court's jurisdiction and do not.
Well, then you are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh.
You can go because you're not a named party.
Good afternoon, Your Honor.
State your name.
My name is Daniel McGrew for the record, Your Honor.
You're going to represent yourself in this matter, sir?
Yes, sir.
I do have to advise you that in this case, you are charged with the offense of assaulting, resisting, or obstructing a police officer. That is a high court misdemeanor felony punishable by up to 2 years and or $2,000 fine plus court costs. You understand that?
I understand your charge.
You understand also that there is great peril in one representing themselves. You understand that, sir?
I'm not afraid, Your Honor.
Did you understand what I just said? That there is great peril in representing oneself.
I comprehend what you're saying, Your Honor.
Tell you what. Either you're going to answer my questions and you're going to answer them properly, or we're going to have a long time and I'm not going to have these people wait. So while you decide how you're going to handle this, I'm going to have you have a seat. I'm going to pass your case. You will come back up and you will learn how to operate within this court. Plain and simple. Have a seat. Have a seat.
All right, guys. We are 3 seconds into this hearing, and the judge already looks like he regrets waking up today. This dude keeps answering every question like he's unlocking secret dialogue options in a video game. I comprehend. I recognize. BRO, just say yes or no. And then the judge hits him with wipe that smirk off your face. Nah, his patience clock is already on 1%. Wait till this gets worse.
Good afternoon, Your Honor. My name is Daniel McGrew.
I have stated the admonishments that I was giving to the defendant representing himself. I apprised him of the maximum penalties and the charges. Apprised him, and sir, I'll ask you the question again. You understand that there can be great peril in representing yourself.
I fully recognize and acknowledge the seriousness of the charges, which include allegations of...
Not my question. You understand that there can be serious peril in representing yourself.
I recognize what you're saying, and I'm fully prepared to proceed with this matter.
Will you just do me a favor and answer my question? Do you understand that there is great peril in representing oneself?
I recognize that.
Okay, then stop there.
Yeah.
You recognize.
Recognize.
Do you understand that that in any of the proceedings that the court would hold you to the same standards as if you were a practicing attorney, will give no leeway one way or the other, will show no favoritism or no bias because you are representing yourself. You understand that, sir?
I recognize what you're saying, Your Honor.
You know what? I don't know why you just won't understand. I'm asking you, and I need a direct answer, whether you understand what I am saying, not whether or not you're recognizing the words. Do you understand what I am saying?
I overstand what you're saying.
You want to be...
Your Honor.
You have a seat.
I'm not...
Have a seat.
Your Honor, I haven't had...
Have a seat. You can play games with me all day. I got all day. I got all day. Have a seat. The other one's in custody. I realize we are now at least caught up within an hour. I think those that want to go probably want...
Nah, bro really pulled out I overstand in a courtroom like he's the final boss of YouTube law school. You can literally hear the judge's soul leaving his body in real time. Every answer is turning into a philosophical TED Talk, and the judge is like, "Sir, please, I'm losing my mind because this man thinks he's winning on technicalities while the courtroom is slowly turning into a hostage situation." And trust me, the judge is done playing nice.
Afternoon, Your Honor. Daniel Magoo. Here in Dewey Juris.
All right, so on this matter, I was apprised you of your rights. I told you about the charges in this case. We get to the point of understanding that there is a certain peril in representing.
Listen, sorry. My notes, I apologize, Your Honor. I meant no disrespect.
And that the court will treat you the same as an attorney in the case. You understand, sir? Listen closely to my question. Do you understand that?
I do not understand.
You do not understand it.
No.
The court, you will be presumed to know the rules of procedure as well as the Michigan rules of evidence, that the court will not be giving you assistance in regard to this case.
What I'm trying to say, Your Honor, is I do not understand the charges that are pitting against me because they violate a lot of my rights. And the prosecutor served me the discovery packet on the 27th of last month. Since then, I have not received any kind of evidence or any kind of claims that I violated any kind of anything that day. So I'm here waiting for that to occur. So no, I don't understand.
Waiting for what to occur?
Well, under the rights to due process, Your Honor, 4th, 5th, 8th Amendment, there has to be substantiated amount of evidence to accuse me of a crime, like assault on a police officer, obstruction of justice, and resisting arrest. I take these charges very serious, Your Honor. Because of these charges, I have lost custody of my son.
Okay, wait, plot twist. The guy suddenly shifts from courtroom philosopher to emotional defense mode. He starts talking about constitutional rights, missing evidence, and then casually drops that he lost custody of his son because of these charges. That got real fast. But even then, the judge keeps trying to drag him back to one simple question, and bro keeps taking the scenic route every single time. You can already feel another explosion coming.
Sir, I just asked you before whether or not you understood the charges.
And I answered you, Your Honor. I said I do not understand them.
Whether or not you disagree with them or not the issue. The issue is do you understand what you are charged with?
Do not understand, Your Honor.
Is there a reason other than what you said that you do not understand?
I can elaborate a little further, Your Honor. I'm still waiting.
I wish you wouldn't. I just need to understand why you don't understand.
I'm trying to get there, Your Honor, if we could talk
I'm
about
not asking you whether or not you agree that you should be charged. I'm not asking whether or not you believe that you did it. I'm not asking any of that. I'm asking whether or not you understand what you are charged with.
Can we agree to disagree on the legalese?
We are not going to agree to anything. This is not your game to play here. You play by my rules.
So you're saying that I have to say the words, I understand?
Sir, I'm not saying that you have to say anything.
Okay.
You know what? Here's the thing. I am not going to play this game with you.
I'm not.
So what? No, you are playing a
I'm
game.
not.
So no, you are. And do not interrupt me ever again. Do not. So what I'm going to do is I'm going to give you a week to think about it, because I'm not going to sit here, call your case up 4 or 5 times for you to sit here and to go through this whole, try to play some semantical game. So I will adjourn this out to December 12th, 2024. I will adjourn it to 9 a.m. or I will. Do not interrupt me.
I can object to
Do
that date.
not interrupt. Do not. One more time, you're going. I've given you fair warning. I'm adjourning the proceeding out. If you are objecting to that, objections noted. It's still adjourned out to the 12th. Bond will continue. You
Your
may
Honor.
leave now.
I have constitutional.
You may leave
violations.
now.
Let's go ahead. Mr.
I have a right to a
You may
counsel.
leave.
Do I not have a right to a counsel?
You want an attorney, you may get on an attorney, sir?
I need somebody to explain the problem here.
Do you wish to be represented by an attorney on this?
I do not need to represent myself. I'm presenting myself. I'm the only one that was there in this courtroom. No one was there. I don't recall anybody that was there that day. I'm the only one that knows what happened, Your Honor.
Do you wish
And I was
to be
violated.
represented by an attorney? I'm not going to sit here and argue with you. If you wish to be represented by an attorney,
Your Honor, I have constitutional violations.
do you wish to be represented by an attorney,
You
sir?
take an oath to defend the Constitution of the United
This right here? Pure courtroom chaos. The judge says, you play by MY rules, and honestly it sounded less like court and more like a mob movie. Then the defendant tries the "can we agree to disagree" line. SIR, this is not Reddit. And when he interrupts again? Oh, the judge immediately goes nuclear. One more time. Yeah, that tone means security is already mentally standing up. But somehow it still gets crazier.
Doshia Banks occupant.
Pardon?
Doshia Banks occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No.
So what is your position in this case as you see it? Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. It is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. This order came out June 24th of this year. I have a copy for you. I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. There is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
All right, now we switched cases, and suddenly we're inside a Netflix real estate scam documentary. Multiple bankruptcies, fake occupancy claims, random people attached to $1 million house. Bro, what is happening in Ann Arbor? The attorney is listing names and court filings like he's reading a criminal conspiracy map off a whiteboard. And the judge is sitting there realizing the situation has more plot twists than a season finale. But wait till the occupant starts talking.
Is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself. The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
The lawyer is cooking right now. He's basically saying this eviction has been delayed so many times that everybody involved deserves a loyalty card. Then he casually asks for $10,000 a month like he's ordering lunch. Meanwhile, the courtroom atmosphere is getting weirdly tense because you just know somebody's about to say something completely unhinged. And oh boy, here it comes.
Just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, is respectfully appear, specially and conditionally, for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then you are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and
No,
then
I have
you
a
can
lease
go
with-
challenge it. With who?
With Whitlow. Miss
Then
Whitlow, who
you
is-
need to go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting.
You're recanting what?
Nashi opened with, I do not consent to this court's jurisdiction, like she watched one legal TikTok and decided she was unstoppable. And the judge instantly goes, then sit down. I almost fell out of my chair. Then she panics and tries to undo IT in real time. I'm recanting. BRO, this is not customer service where you cancel the cancellation 5 seconds later. The judge is looking at her like he just adopted a migraine.
But I just stated
Which part?
the part that I stated that I'm not. Oh, I lost my spot. Not consenting to this court's jurisdiction. So I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment. Oh,
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
okay.
You know what? Here's the problem. You've not filed anything with this court.
No.
So I don't know why, on those grounds, why I'm hearing from you.
Okay. If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false
answer and
pretenses
counterclaim to what?
to their complaint for eviction.
You have a lease with, allegedly, with Miss Whitlow.
Correct.
then that is who you need to pursue it against,
Okay. And,
or whatever the heck you're doing.
well,
Because there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
okay, I'm not really understanding, but
Well, let me put it a little bit more simply. If I grant the relief of the plaintiff in this case and grant an order of a judgment and an order of eviction in
Okay.
10 days,
okay,
any claim of your interest in that property, you have to go after the Whitlows because that's the only person you have a contract with. Allegedly have a contract with.
okay. No, there is an actual contract.
I don't know that, ma'am.
We've actually been.
I don't know that.
Okay. I know you don't know that 'cause it's not before you.
Correct.
At this point, the judge is basically teaching Courtroom Law 101 against his own will. He's trying so hard to explain that her issue is with the person who gave her the lease, not the property owner. But every explanation somehow creates more confusion. You can hear her brain buffering in real time. And when the judge says there is no privity of contract, yeah, everybody outside law school just collectively blinked twice.
I see. So basically, the notice of removal that the Whitlows did,
They are not here. I don't know. I have documents that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so, as far as I'm concerned, any relief they're requesting, I can, and as of right, ought deny, and it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
stating to me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't-
telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have right to own the property.
Okay. All right, Your Honor, I will speak with the Whitlows that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
This whole exchange feels like somebody trying to patch a sinking boat with duct tape. The judge starts dismantling every argument one by one, and signed documents, missing people, absent filings, it's bad. Then she slowly realizes the people she trusted basically vanished into thin air while she's left standing in court alone. Yeah, that silence after the judge says they're not here hit different.
Based upon the representation of counsel, I'm going to grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment in order, the appeal bond I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order. Thank you.
Thank you, Your Honor.
And here comes the finishing move. The judge grants the eviction, then drops a $15,000 monthly appeal bond like he's announcing the price of a luxury yacht. The occupant tries to object, and the judge immediately shuts it down with courtroom sniper precision. You do not have standing. OHHHH, that one hurt. Absolute chaos from start to finish. If this courtroom meltdown had you losing your mind too, like, subscribe, and follow for more insanity on Case File USA.